Good morning, everyone. Judge Missy is trying to fix her view of the screen. She'll be here momentarily. Thank you.
All right. Can you hear me?
Say something.
Hello? Can you hear me?
Yes, Your Honor.
Yes, we can hear you.
Oh, the announcement for 34, this is Mr. Wilson. The announcement is that we would like to reset the case to June 5 SAP calendar.
At 34?
Ms. Kim, hold on 1 second. We not actually
Yeah.
announcements
Hold
yet.
on. Let's make
Judge is
sure
trying the judge is trying to get together. Trying to check her view. Judge Mincy,
yes.
come.
Now I can see courtroom 2.
Okay, you can?
Yeah, I can see them now.
Okay.
And I can see you and the court reporter, and that's it.
Okay. You can make your announcements, Your Honor.
All right.
You have
Let's
any
get
announcements, but
right.
hold
Let's
on. Okay.
get
Did
started
you print,
for the
Your Honor,
essay.
did you print out your calendar?
I did. I got that one.
Okay.
I don't think that I have the competency one. Let's see.
We don't have a recommendation for that. So you good.
Oh, we don't.
I just
Okay.
emailed you. No, ma'am.
Okay, good. All right, let's get started then with just the regular SAP. Oh, I still don't have anything from the state. I didn't get that.
You don't have your recommendation, Your Honor. That's what Miss Kim sent.
Have what
I
Ms.
mean,
Kim-
I'm sorry, the announcements for, you don't have that. It came from Miss Kim.
Okay, I have that then.
Okay.
I was thinking I was missing something, but I'm not.
No, Your Honor, you're good.
Okay, good. All right. Well,
And
we're
Your
ready,
Honor,
ready
you
to
have the
start.
state's recommendations, right?
Yes,
No,
I
I don't.
emailed it to her, Miss Fox.
Oh, let's see. I have,
I sent
Email
those,
that's the email that I sent you, Your Honor, that you said that you didn't get.
right, and
I'm,
I sent those Tuesday evening.
I'm printing that now. That was the 3 pages. Well, it says state all-purpose add-on.
Yes, it's one for the add-on and it's one for the regular SAP.
I apologize. All right, I'm printing now and then I'll be ready in half a second. Sorry, everyone. All right, we're ready to begin. The state all purpose for Thursday, May 22nd, 2025. Who do we have first?
Yes, this is position number 34, Mr. Wilson. And our announcement is that we would like to reset this case to SAP June 5, 2025.
Okay. All right, is that okay for the state?
Yes, but I do want to make all parties aware that his recommendation would have released him today. So obviously, a reset will not allow that to happen.
Well, there is another felony charge that he has to deal with.
Okay, completely understand. Thank you.
Thank you.
Okay. We're going straight down the calendar, position 1.
Okay, I'm gonna do, position number 33, Mr. Two.
33.
Right here. We're gonna do number 3, Collins.
So position 3, 25 CR 002439G, Brittany Carter.
Brittany Carter is released, Your Honor. So is this the position 3 on the add-on?
Oh,
Courtroom 2, you have Brittany Carter there?
No, she just left out the courthouse.
This is position number,
It's 4 and 5, not 3.
I'm sorry.
Oh.
Okay, thank you. Thank you, PD White.
okay. All right, this is Christopher Collins. 24 CR 006888J and 25 FTA A 000941. And these are going to be a plea,
That's correct, Judge.
Attorney White. Okay, go ahead, state.
Yes, Your Honor. On position number 4, the state's recommendation on the criminal trespass is 12 months served, 50 days, credit for time served 25 days from October 5th to October 8th of 2024 and May 2nd of 2025 until today. Balance probated, stay away from 1761 Timothy Drive Southwest. Count 2 would be 6 months concurrent with count 1, a $500 fine. The defendant needs to attend the BARK Animal Cruelty Online course, a $500 fine, or 50 hours, of community service. Defendant may not own any animals or have any animals in his household. Position number 5, the state will be entering a null pros upon the acceptance of the plea on position number 4. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
All right.
Hold on, Judge.
Okay.
We can proceed.
All right. And so understand
Sorry
that
about
this,
that, Judge.
okay, this is a negotiated plea.
And Judge, we are asking that you accept the state's recommendation. We're in agreement with that, would stipulate for the purposes of the plea. And he is choosing to do the 50 hours of community service. We would ask that the probation terminate or go non-reporting upon completion of all of the requirements.
State has no objection to termination.
Okay. So termination upon completion. All right, and so the defendant, Mr. Collins, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury? All right, put your hand down. So it's my understanding that you wish to plead guilty today to 1 count of criminal trespass and 1 count of cruelty to animals. Is that correct?
Yes, ma'am.
All right, I'm going to ask you a series of questions to make sure that you understand your plea and that it's free and voluntarily given.
Yeah.
And the first question I need to ask you is that are you under any influence of any unprescribed medication, drugs, or alcohol that would impair your understanding of this plea today?
No.
I didn't hear you.
No.
Okay. Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Okay. Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Has anyone promised you anything to plead guilty?
Oh, ma'am.
All right. Has anyone told you that you'll receive a lesser sentence if you plead guilty?
No, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
All right. And do you understand that if you're currently on probation, your probation may be affected or revoked because of the plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with full understanding of the charges against you?
Yes, ma'am.
So as to the charge of criminal trespass, how do you plead?
I plead guilty.
And as to the charge of cruelty to animals, how do you plead? All right, I will accept your plea. And you understand the conditions your attorney has explained to you that you must complete while you're on probation, correct? And then once you complete those, then the probation will terminate.
Yes, ma'am.
Okay. All right. Anything else, counsel?
Nothing from defense, Judge.
Nothing from the state.
All right, then that plea is accepted.
Thank you, Your Honor.
All right,
Number-
thank you.
Number 33, two.
Judge Menzies, Mincy, I'm sorry for interrupting. The microphone in courtroom 2 is really hard to hear, so
It
if
is.
the attorneys could just try and speak towards the microphone, whenever they turn their head away, I can't hear anything.
You can't hear it. Yes, it's
I'm
a little
sorry.
hard for me.
Thank
Right, a
you.
little hard for me as well.
Okay.
Come on, Ricky Smith. Add on position number 3, Ricky Smith.
That's also.
Hold on. You need to speak to him too. Hold on, Rick. Position number 18, Mr. Nicholas McLaurin.
Judge, this will be a negotiated plea.
Okay. Nicholas McLaurin,
Yes, ma'am.
charge of 1 count of theft by taking. 25 CR 002032H. All right, go ahead, state.
Yes, Your Honor. The state's recommendation on this case is 12 months served 90 days, credit for time served 36 days from April 17th, 2025 until today. Balance probated, anti-theft course, 40 hours of community service, no further contact with Sophia Sanacor, and stay away from Georgia Tech property. At this time, we would like to sound from Ms. Sophia Sanacor, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
All right. Mr. White,
So stipulated, Your Honor, we just asked the probation terminate upon completion of the requirements.
State has no objection to non-reporting.
non-reporting. not termination?
Correct, Your Honor.
All right, Mr. McLaurin, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am, I understand.
All right, put your hand down for me. And I understand that you wish to take a plea today to one count of theft by taking. Is that correct?
Yes, ma'am, I understand.
All right. And I'll ask you a series of questions to make sure that you understand the plea that you're taking today. The first one is, are you under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding today?
No, ma'am.
All right. Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Understand, yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you prepared and agree to waive these rights today, is that correct?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And that you do understand that if you are currently on probation, your probation may be affected or revoked because of the guilty plea today? And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you? So do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, 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 sir. Yes, ma'am.
All right, as to the charge of theft by taking, how do you plead?
I plead guilty, ma'am.
All right, and you understand your conditions while you're on probation, is that correct?
Yes, ma'am.
All right, so after you complete those conditions, you'll just go non-reporting.
Yes, ma'am.
Thank you, Your Honor.
All right, thank you. Please accept it.
All right, good luck. No problem.
Position 1, Michael Blackman.
Okay,
It's also a negotiated plea, Judge.
all right. 25 CR 002401E, Michael Blackman, charged with 2 counts of terroristic threats and acts. State?
Yes, Your Honor. On count 1, the state's recommendation is 12 months served 32 days. Credit for time served 16 days. That's going to be from May 7th, 2025 until today. Balance probated, no further contact with Tykeria Redding. Stay away from the whole of the Fulton County Library System, 12 weeks anger management. On count 2, we'll merge with count 1. We do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. We would at this time like to sound for Miss Tykeria Redding.
Ms. Redding? She on the Zoom?
It doesn't appear so, Your Honor.
And the
Um,
state does not object to non-reporting on this one.
Okay,
Judge, we do stipulate for the purposes of plea, and we're fine with non-reporting.
all right. And so, Mr. Blackman, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down for me. And I'm going to ask you a few questions to make sure that you understand the plea that you're taking today. And the first one is, are you under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding at this time?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you would receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, that could be revoked or affected because of your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, as to the charges of 2 counts of terroristic threats and acts, how do you plead?
Yes, ma'am.
How do you plead to those that you're doing?
Guilty.
Okay. All right, and you understand your conditions while you're on probation, correct?
Yes, ma'am.
All right, and after you complete those conditions, you will go non-reporting.
Okay.
All right, thank you.
Thank you, Your Honor.
All right, please accept it.
It means once you get all this stuff. So knock that out.
Okay, 12 months of anger management,
12 weeks.
12 weeks. Okay. Thank you.
Number 8, Devontae Irwin.
We're not ready for Mr. Irwin yet. We don't have an offer on.
What about number 11?
Have a seat, I get back to you. Yeah, right now. What's that? Who is it?
Hodge. Let me see that.
Yeah, we can do it.
Number 11, Mr. Christopher Hodge.
And Ms. Falk, if you could just put the offer for position 8 in the chat to it as soon as we're done with Mr. Hodge.
You're on mute.
I cannot hear Mr. White at all. I'm sorry.
Oh,
Does that help?
okay.
Does that help?
I can understand. Does that help?
Miss
all I'm
Howard,
saying.
I think it may be your microphone because I can hear him quite clearly.
Yeah, I heard him.
Yeah, I had no problem hearing or understanding him.
And I'm sorry, Ms. Falk, if you,
Yes, I'm putting it in there now.
yeah, okay, because it somehow or another didn't print on my calendar.
Yeah.
Okay, but we are ready to proceed with position 11.
Okay, 11, and that's
Mr.
Christopher Hodge,
That's correct.
25 CR 002432J. Charged with 1 count of disorderly conduct, 1 count of public drunk, and a 3rd count of criminal trespass. State.
Just a moment, Your Honor. I was just
Okay.
finishing.
Oh,
Okay.
that's right. You were.
Yeah, no, not a problem. Okay, so on position 11, the state's recommendation is to the disorderly conduct is 12 months served 30 days, credit for time served 15 days. That's going to be from May 8th, 2025 until today. Balance probated, stay away from Longhorn Steakhouse at 3480 Camp Creek Parkway in East Point. ADET, no further contact with Nasir Kareem. Counts 2 and 3 are going to be 12 months probation concurrent with count 1. The state would ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. We would like to sound for Mr. Nasir Kareem at this time. That's all for the state.
All right. Mr. Nasir Kareem. I don't think he's on.
Judge,
Go ahead, Mr. White.
sorry, Your Honor, we do stipulate for the purposes of the plea and just has the probation terminate once he completes his ADET evaluation, so long as there's no treatment requirement, which we don't anticipate.
Dave.
Let me just look at one thing. I just want to look at his history. I'm either going to be agreeable with non-reporting or termination. I don't quite remember his history, so it would just help me to take a look at it and refresh my recollection. State's okay with non-reporting.
Okay. All right, Mr. Hodge, I understand that you wish to plead guilty today. Is that correct? Mr. Hodge?
Yes.
All right. Yeah, you're gonna have to probably lean forward so that the court reporter can hear your responses. I'm going to ask you a series of questions to make sure that you understand the plea that you're taking today. The first being, let me give you the oath. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, put your hand down for me. First question is, are you under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding today? You have to say it, speak it.
No, no,
Okay. Are you satisfied with the services and representation of your attorney?
yes,
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
yes,
That you're giving up and waiving the right to remain silent and not testify against yourself?
yes,
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
yes,
And you are prepared and agree to waive these rights today, is that correct?
yes,
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
no,
Has anyone promised you anything to plead guilty?
nope,
And you understand that if you're currently on probation, that probation could be affected or revoked due to the guilty plea today?
well,
All right. And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
yeah, sure, yes,
Okay. And so as to the charge of disorderly conduct, how do you plead?
guilty,
As to the charge of public drunk, how do you plead?
I do guilty,
I'm sorry.
I do guilty,
All right. And as to the charge of criminal trespass, how do you plead?
I do guilty,
All right. I will accept your guilty plea, and I believe you're going to go non-reporting after you've completed all the conditions.
Thank you, Your Honor.
All right. Thank you.
Position number 23 and 24, Patterson.
Your Honor, this is a negotiated plea.
All right. This is Lazarius Patterson.
Yes, Your Honor.
All right. And we have 23 CR 004720E and then the FTA associated with that. And we have one count of simple battery. Is that correct?
Yes, Your Honor.
Okay. Go ahead, State.
Yes, Your Honor. On the one count of simple battery, the state's recommendation is 12 months served 30 days, credit for time served 10 days. That is from July 31st, 2023 to August 1st, 2023, and then May 15th, 2025 until today. Balance probated, 12 weeks of anger management, no further contact with Jose Brito Nunez. Stay away from GSU, the entirety of the Georgia State University property, and 40 hours of community service. On position number 24, the state will be entering a null pros upon the acceptance of the plea on position 23. We do ask for the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We would like to sound for Mr. Jose Brito Nunez, and we do object to early termination or non-reporting. That's all for the state.
Jose Brito Nunez, I believe. See on the Zoom. Nope. All right.
Yes, Your Honor, we do stipulate for the purpose of the plea. Only thing is though, he does not have a job right now and he has to stay in a jail for 5 more days. Can he have probation fees waived for first 2 months to help him out?
All right, I will waive the probation fee for 2 months.
Thank you, Your Honor.
Okay. All right, so we're ready to take the plea.
Yes, yes.
All right, raise your right hand for me, Mr. Patterson. Do you affirm that I'm sorry? All right, do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury? All right. Did you hear me?
Yes,
Okay, then you can put your hand down. And I understand that you wish to plead guilty to 1 count of simple battery. Is that correct?
that is correct.
All right, I'm going to ask you a series of questions to make sure you understand your plea today. The first one being, are you under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding today? Did you hear me?
Yes.
Okay. Are you under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding today?
No,
All right. Are you satisfied with the services and representation of your attorney?
yes,
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
that is correct.
That you're giving up and waiving the right to remain silent and not testify against yourself?
That is correct.
And that you're giving up the right to trial by judge or jury, whichever you prefer?
That is correct.
And are you prepared and agree to waive these rights today?
Yes,
Has anyone told you that you will receive a lesser sentence for pleading guilty?
nobody has.
All right. Has anyone promised you anything to plead guilty?
No, ma'am.
And that you understand that if you're currently on probation, your probation can be revoked or affected by a guilty plea today?
That is correct.
All right. And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes,
All right. And as to the charge of simple battery, how do you plead?
guilty.
All right. I will accept your guilty plea. You understand your conditions. I'm going to waive 2 months of the probation fees to help you get started. And you understand the conditions of what you have to do and to stay away from Georgia State University, right?
Correct.
While you're on probation.
Why am I on probation?
And that was correct, right, counsel? He's to stay away from Georgia State University.
Yes, Your Honor. Wow.
Yes, Your Honor.
All right, you can do that, right?
I'm a senior there currently, but I guess if it's part of the order, I guess I kind of have to I haven't transferred and I guess I have to transfer. Yes, I can do that. I can do that.
They,
Your Honor, if he's saying he's a student there, if he can provide proof of that to probation, the state is willing to lift the restriction on him being at school.
right.
He'll just need to provide proof that he is currently enrolled at Georgia State to the probation department.
All right, do you understand that?
Absolutely.
PD?
I was going to say I can transfer if I have to, but I am a senior there. But if I have to transfer, I can. I'm just trying to figure out where to go.
Oh, well, we're not trying to hinder you from graduating. I am concerned if you're a senior and you don't have much more coursework to complete, but we also want to make sure that there are no other incidents either.
Correct.
So I don't know, you may want to talk to your attorney about it, but the state is willing to allow some modification of it based on you showing proof that you're currently enrolled. I don't know if you can take all your courses online. I don't know what that looks like, but just going to need to provide that proof to probation so that
Right.
then the conditions can be modified possibly.
I can do that.
Okay.
Thank you.
All right. Thank you.
You're good, sir. Add-on position number 4, Mr. Taylor.
This is also negotiated plea, Your Honor.
Okay. All right, this is 25 CR 0023331 Nathaniel Taylor, charged with 1 count of simple battery against a police officer, dog or correction or detention officer, disorderly conduct, and reckless conduct. 3 charges. State.
And this is on the add-on calendar, is that correct?
Yes, add on.
I found it.
add-on
Your Honor.
4.
Thank
Okay.
Count 1 is going to be 12 months served, 40 days, credit for time served, 20 days from May 3rd, 2025 until today. Ballots probated, Operation 21 law and decision-making class. Count 2 on the disorderly conduct, 12 months concurrent with count 1, and 60 hours of community service. Count 3, the reckless conduct, will merge with count 2. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
All right, PD Kim.
Yes, Your Honor, we do stipulate for the purpose of the plea.
All right. And so, Mr. Taylor, understand that you wish to plead guilty today. Is that correct?
Yes, ma'am, that is correct.
All right. Raise your right hand for me. I'm going to swear you in.
Raise your right hand.
Raise your right hand.
Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
So,
Okay. Put your hand down for me. I'm going to ask you a series of questions, and I need to make sure that you understand what you're doing and that you're entering this guilty plea freely today. Okay.
yes, ma'am.
All right. The first question is, are you under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding of the plea today?
No, ma'am.
Are you satisfied with the services and representation of your counsel?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yeah, yes, ma'am.
Are you prepared and agree to waive these rights today?
I am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked or affected because of the guilty plea today?
Yes, I do understand that.
Okay. And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Your Honor, I apologize for interrupting. I need to talk to him a little bit more about another issue. Can we have a little break? I apologize.
Okay.
Good morning, Judge. I have position number 2, Ms. Cameron.
Okay. State, are you okay? We can go to 2 and come back. I usually don't like to stop in the middle of a plea.
That's fine, Your Honor.
Okay.
Oh, I'm sorry, Judge. I didn't know you were in the middle of the plea. If that's the case. then
We were,
wait.
but PD Kim asked to go talk to her client. I'm
So,
assuming they're not coming back too soon, but in the essence of time, let's go ahead and take this one.
Good morning, Your Honor. How are you?
Good morning. How are you?
Good.
All right. This is position 2, Demetria Cameron. Is that correct?
Yes, that's correct, Your Honor.
All right. 20 COV 000397. No.
Yes, that's correct.
All
Zero
right.
20
1
zero.
count of stalking. Is it
That
one
is
count of
correct, Your
stalking
Honor.
is a charge? Okay.
Yes, Your Honor.
All right, go ahead, State.
State's recommendation is 12 months served 26 days, credit for time served 13 days. That is going to be from May 10th, 2025 until today. Balance probated, a $300 fine, 40 hours of community service, and no further contact with Courtney Williams. At this time, we would like to sound from Ms. Courtney Williams, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Yeah, this isn't gonna be a plea.
Oh,
I
My
emailed
apologies.
Ms. Falk, did you have a chance to look at that? Regarding-
I have not. I apologize. You
All right,
sent me
that's
an
fine.
email.
All right, I probably should have said something earlier, Your Honor. I think this case is subject to a general demurrer. The accusation charges her with stalking, but the accusation and the citation and the police report say nothing about the elements of stalking. All the accusation and the police report and the citation say is that she violated the protective order, and that's not an element of stalking. It was the incident allegedly occurred in 2020, so it is outside the statute of limitations. So we would ask either if the state consider null pros, or if not, if the court would give her a signature bond. This case is all that's holding her in, Your Honor.
All right, State.
Your Honor, I think that is a motion, any kind of motion for demurrer would need to be taken up by the trial court. This is not the appropriate place, the forum, or the appropriate amount of notice for a motion like that. So the state would, not entertain this motion at this time and ask the court not to entertain this motion at this time. I will say the defendant was released on a $3,500 bond on simple assault, battery, family violence, and criminal damage to property in the second degree. So this was not the only case the defendant was arrested on. She was also arrested on those charges, which include a felony charge. She posted bail on the 15th of May on the other charges that she had accrued. And so this is the charge remaining. It is a $2,000 surety bond. And let me just take a look at something.
Okay.
I just want to see if it's a bench warrant as well. If Your Honor can just give me a moment.
Okay.
I would assume it was, given the date of the incident. And the other case, Your Honor, just so you can take a look at it for yourself if you would like, that felony case is under 25 PI 003711. So it has not been accused. It hasn't been indicted yet since it was just happened about 11 days ago.
Oh, 11 days ago. Okay.
Right. So it looks like the defendant did fail to appear on March 2nd of 2022 on this case. And so the state would ask that one or the other, either the case be sent to the trial line to be addressed, since the defense has apparently a motion they would like to have entertained by the trial line, or that the defendant remain in custody until, in either instance, the defendant remain in custody until that motion and can be addressed, as well as the bench warrant, especially considering the defendant has a history, including this most recent arrest for felony charges that is currently open and pending as well.
Well,
And go ahead.
well, Your Honor, if I could reply to that, even if all of that is true, it's irrelevant to the issue of whether the accusation was legally sufficient. She's charged with stalking. The elements of stalking are contact without the person's consent for the purposes of harassment or intimidation, or publishing or disseminating the person's contact information without their consent so that other people harass or intimidate her. The accusation only says that she violated a protective order.
But I understand, counsel, that we're not going to address that motion today because I don't know, when did you serve it upon the state? They don't.
I don't believe he has, Your Honor. I
Okay,
haven't received a notice of the motion.
An email, Your Honor, but the state deals with this argument all the time. I think Ms. Falk is perfectly aware of Strickland versus State. If the court is not going to hear arguments about that, we would at least ask for a signature bond, because she shouldn't be held in jail on a case that can't be prosecuted.
And Your Honor, is
I-
PD
and-
Bartels actually arguing that an email is sufficient notice of a motion for a general or special demurrer?
I don't think so.
I'm saying, Your Honor, she shouldn't be held in jail because this case can't be prosecuted.
I
It's-
understand, but that has to be determined and that has to be heard.
That is correct.
And that issue is not before the court this morning.
I mean, we can all pull out our law books. It's really.
Yeah, I mean, it's Strickland versus State, 349 Georgia Appeals, 673, 2019. I'm sure Ms. Falk is.
I'm not doubting anything that Ms. Falk is familiar with. The problem is notice and proper service upon the state to be able to argue that motion. And this is not properly before the court with that motion today. Also, the defendant has FTAs, which would not make me comfortable in the meantime, allowing her to be released on a signature bond.
Okay, well, we'll ask that she be arraigned, Judge, so that the accusation can be read.
That is fine. So does she want to waive the reading of the formal charges or?
No, we would not wait. We would ask that the language of the accusation be put on the record.
All right. State,
He need to sit down. He need to sit down.
Yes, Your Honor. I
All right.
assume Your Honor is asking me to read it into the record.
yes, I was getting ready to say the case number, which is 20 COV 000397. And that charge again is stalking. And if you could read the formal reading of the charge into the record, I would appreciate it.
Yes, Your Honor. On behalf of the citizens of Georgia, do hereby charge and accuse Demetria Latasha Cameron with the offense of stalking, a misdemeanor for that said accused in the county of Fulton, state of Georgia, on or about September 11th of 2020, did violate Protective Order 2020 CB 339522 by coming within 200 feet of the victim, Courtney Williams, in violation of OCGA 16590, contrary to the laws of this state, the good order, peace, and dignity thereof. And it's signed by Keith E. Gamage.
All right. And so now the formal charges have been read into the record. Miss Cameron, you have been formally charged with 1 count of stalking. And you will again be noticed, further noticed for trial, and as well as the motions calendar by the division judge. And you understand you have your counsel. He will advise you as to how you proceed. You do have the burden to be ready for trial. And of course, you have a right to counsel, which you do have. So this case will be further noticed.
Which judge is that?
I do not know.
A judge had to be assigned to it, Mr. Bartels. This was a COVID case, and it was in Orca at the time, and because it was a COVID case, and she was released on citation. In the state filed the amended accusation back on March the 3rd of 2022 that Ms. Falk just read. So it will get a judge assignment. Right now, I don't know what the judge assignment is going to be at this point, but it will be put in shortly as soon as we get a judge.
Do you know
assignment.
when that decision will be made?
Give me about 5 or 10 minutes and I'll let you know what judge it is.
All right, perfect. Thank you.
All right. Mhm.
All right, thank you.
Thank you.
Ms. Kim, you ready? Yeah. Come on.
Right.
Your Honor, our announcement is, we would like to reset this case to next Tuesday.
Right.
All right, and this was
Oh, position four. I'm sorry. Okay.
Taylor, add on calendar, position number 4.
Okay,
We find out.
So reset for next Tuesday
Please,
or next Thursday?
Tuesday will be better.
all right, Tuesday, the 27th.
Yes, Your Honor.
I'm sorry, Your Honor, and Ms. Falk, this is 34, right?
No, this is position
Add-on.
4 on the add-on calendar.
Position 4 on the add-on, and what's the
Yes,
rest
Ms.
of the
Young.
date?
They're requesting the 27th, which is that Tuesday. So
Okay.
it would need to be an add-on if there is room on the calendar.
Yes, ma'am.
Is that okay,
Yes.
or,
Yes, ma'am, that's fine.
okay, all right, thank you.
Thank you, Your Honor.
Well, we said 27.
We're gonna go to position number 26, Martin Reyes.
Okay,
Oh, man, you're taking a blue. You're taking a blue, right?
We want to results.
Yeah.
Get back.
all right, this is 25 CR 0024550C, Martin Reyes, charged at 1 count of willful obstruction and 2nd count of criminal trespass. Is this a plea?
Yes, this is negotiated plea. We would like to request that $300 fine to be converted to 30 hours of community service.
All right, state.
My apologies. The state has no objection as long as the defense understands that that would make for a total of 90 hours community service, since there was 60 hours of community service assessed on the criminal trespass.
Yeah, he understands that.
Okay.
All right. All right, go ahead, state.
Yes, Your Honor. On the willful obstruction of law enforcement officer, the recommendation is count 1, 12 months served 26 days, credit for time served 13 days from May 10th, 2025 until today. Balance probated Operation 21 law and decision-making course and 30 hours of community service in lieu of the $300 fine. On count 2, the state's recommendation is 12 months concurrent to count 1, stay away from all GSU premises and property, 60 hours of community service. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea, and we do object to early termination, but we do not object to non-reporting after he's completed the conditions. That's all for the state.
All right.
Thank you, Your Honor. Since he does not have any job, can he also have 2 months of probation fees waived?
I'll waive 1 month of probation fees.
Thank you.
All right. And so, Mr. Reyes, understand that you wish to plead guilty. Is that correct?
Yes, ma'am.
All right, raise your right hand for me. I'm going to swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, speak up a little bit so the court reporter can hear you, or speak closer to the mic. I'm going to ask you a series of questions to make sure you understand your plea, okay? Can't hear you.
Yes, ma'am.
Okay, you put your hand down. First question is, are you under the influence of any medication, drugs, or alcohol at this time that would impair your understanding of the plea today?
No.
All right. And are you satisfied with the services of your attorney?
Ma'am.
I'm sorry?
Yes, ma'am.
Oh, okay. And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And you're waiving and giving up the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And do you also give up and waive these rights freely today?
Yes, ma'am.
Has anyone promised you anything to plead guilty?
Ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
All right, and you understand that if you're currently on probation, that probation could be revoked or affected by the guilty plea today?
No, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes. Yes, ma'am.
All right. And so as to the charge of willful obstruction, how do you plead?
Guilty.
And as to the charge of criminal trespass, how do you plead?
Guilty.
All right, I will accept your guilty plea to both, and you understand that you have the community service and other conditions, and once you complete all of those, you will go non-reporting.
Yes, ma'am.
All right, now I'll just waive 1 month of probation fees. All right, that's it. I will accept your plea.
Thank you, Your Honor.
Add
All
on position number 3, Ricky Smith.
Okay.
Ms. Fox. On Mr. Martin, he has an additional open case. Are we addressing it?
On Mr. Martin, let's see.
Martin Reyes is the 23 CR case.
Oh, Mr. Reyes.
It's 23 CR 0000585C. Simple battery, family violence.
I was unaware that he had an additional open case. What we can do is the defendant.
It's on the recommendation calendar.
Oh, let me go back and double check. I didn't. What position is it on the calendar?
It's 26, but it was on the recommendation calendar, how they inserted the open case and they offered him. It's a global offer.
Ooh.
Okay, maybe I'm looking at the wrong place. I don't see it on the notes that I have, but let me just double check.
I apologize. It goes with case 42623. It's not Mr. Reyes. My apologies.
No problem.
Not a
Oh.
problem.
It goes with another case.
Okay, not a problem, Miss Young. I was freaking out. I was like, I do not see this on my calendar.
No, I put notes. I put the notes on the wrong number. It goes,
No
Bye.
worries at all.
All right.
Add on number 3, Ricky Smith.
This is also negotiated plea, Your Honor.
Okay.
Your Honor, let me know when you're ready for me to begin.
Uh-huh. Okay.
Don't worry.
This is position 3 on the add-on.
Yes, Your Honor.
Okay. All right, go ahead.
Okay. On Ricky Smith, the count of criminal trespass, the state's recommendation is 12 months served, 34 days, credit for time served 17 days from May 6, 2025 until today. Balance probated, Operation 21 law and decision-making course, 40 hours of community service, stay away from the Stay Express Inn and Suites at 6690 Shannon Parkway in Union City. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
All right.
We do stipulate.
Pam?
Yes, we stipulate, so Your Honor.
I'm sorry?
We stipulate for the purpose of the plea. We stipulate.
All right, Mr. Smith, this is 25 CR 002383Y. Understand that you wish to plead guilty to 1 count of criminal trespass. Is that correct?
Whatever.
All right, raise your right hand so I can swear you in. All right, do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
Okay, you can put your hand down. And then I'm gonna ask you a series of questions to make sure you understand the plea today, okay? First question is, are you under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding of the plea today?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
And you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you're prepared and agree to waive these rights today, is that correct?
More definitely.
Okay, and has anyone promised you anything to plead guilty today?
Now,
Has anyone told you that you receive a lesser sentence for pleading guilty today?
now,
That's the best I can do.
All right, and do you understand that if you're currently on probation, your probation could be revoked or affected by a guilty plea today?
yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you, or the charge against you?
Yes, ma'am.
All right, and so as to the charge of criminal trespass, how do you plead?
Yes.
We can revisit.
All right, and I will accept your guilty plea. You have certain conditions to complete, Mr. Smith. State, is he going to go non-reporting afterwards or terminate?
The state has no objection to termination after the completion of the terms.
Okay, and so your probation would terminate after you've completed all the terms. All right, I will accept your plea, Mr. Smith. Good luck to you.
Excuse me, miss.
I can find Bill.
I didn't hear you, or maybe it was talking.
This is a product.
Yeah.
Trying to know what home tomorrow.
Yeah.
Tonight.
Position number 33, Schultz. Yeah, you got to talk, Carter. Carter.
Well, we're not gonna get into the position. That's not the purpose of the hearing.
33. Schultz. Okay.
Okay, 25 CR 002433C, Javotis, 2.
Yes, Your Honor, we have an announcement that we would like to reset this case to June 3rd, 2025.
You know,
All right, state.
so
Between them.
I'll see if the judge will take the plea, but I'm not going to, because they have no cases.
So we'll reset that to June 3rd. Is that any objection from the state?
Everybody is not doing what they should, unfortunately.
Your Honor, I'm just checking one
Okay.
thing.
Okay.
No, there is no objection for the state. Although this recommendation would have released him today, he is being currently held on a felony warrant, and so he would not have been released today based on that.
Okay, thank you. All right, who do we have next?
So what is it?
Well, Ms.
that's-
Kim got to interview the last person here in the courtroom. So we-
Okay,
Announcements in the meantime,
Just set the case for the.
position 6. He refused, he did not appear at the booth yesterday when I tried to interview him, and he refused to come to court today, so we'd have to reset him to 5/27. If,
Ms. Young, is that okay?
That's fine, Your Honor.
Okay.
and,
All right, so,
PD White, I apologize. I didn't mean to interrupt. On position 6, is that do you need the court to order a social worker visit or no?
I have no idea, because I mean, I haven't had any, sometimes it is very often an indicator of that.
All right.
Sometimes it's just, they don't want to be bothered, so. But if there is no movement Tuesday, I will try to get a social worker out there to go see them. And the same announcement on position 8, we're asking to reset that to 5/27.
Who was that, Mr. White?
Position 8 as well.
Thank you.
Can I make a request on position 8, given the jail time? Can that be reset to Thursday? Because I know 5/27, the calendar was already published, so we're just doing add-ons at this point. given the jail time, it wouldn't change if he gets set to 5/29 that Thursday.
Okay. Let's do the 5/29.
I believe that's all I have. Thanks, Judge.
All right, thank you.
Yes, Your Honor. If we could briefly revisit number 2, Ms. Cameron. I talked with her. I had a conversation with her. She is very concerned because she has 3 children that are school aged, one of whom is disabled, and she has to take them to appointments. Her sister is looking after her kids, but she indicates that her top priority to me is to get out of jail. I've advised her about my position on this case, and I think I've made my position clear. I don't believe there is a case that can be prosecuted. But she did ask what the plea offer was. I told her the state's offer was basically time served, probation, community service, and a fine. She told me that she wanted to take that plea, and I advised her that, you know, this is what the offer is, but I can't represent her if she's going to enter a plea on this case. The other option I had mentioned to her was, I understand what the state's position is regarding notice. Perhaps this case could be reset 1 week and have a hearing on a general demurrer then. Those are where we are. And Ms. Cameron, maybe you could tell the court what you'd like to do.
I wanted to see if I could take like a plea deal. Because I really need to be around my son because he's disabled. He got ADHD and I can't really take care of him. He's out of appointments. I can't miss his appointment. If I miss his appointment, DFAC's gonna come after me. And if I'm not trying to have,
I don't know that DFACs will come after you, and I'm certainly not trying to give you advice, but you know, you've spoken with counsel, taking a plea is pretty serious. And so I think he's just trying to advise you of the consequences of a guilty plea
And I would
versus waiting
also
to have
say-
this hearing.
I mean, the offense of stalking is a recidivist offense. So I want to say either second or third is a felony. So, you know, that's where we are.
I'm not trying to you say guys that if I do it for a week, I got to sit here for another week. I already been here 13 days a week. I don't care about any of it. I just want to be with my kids. That's all matters to me is my kids.
Oh, I understand. But as the judge, I can't advise you. You're talking to your attorney who's very competent in giving you good advice to think about. And I know that people just want to get out at all costs, but you know, later in life or other consequences could be affected by a guilty plea. But you know, if you make that decision to represent yourself and take a guilty plea today, then you would have to do that pro se because you would not be represented by counsel.
And Judge, we would also renew our request again for a signature bond. This did happen allegedly almost 5 years ago. I'm told that there's been no contact between the alleged victim and Ms. Cameron. So we would renew our request for a signature bond based on that, as well as the arguments I've already made.
I think the problem with the signature bond is her history. And I need to make sure that, you know, she's going to come back to court. And we have the, she's on a felony bond is correct. Also, is that correct?
That is correct, Your Honor. She was given a felony bond on that 25 PI case that she picked up at the same time she was picked up on the failure to appear on this case.
And again, Your Honor, they can't prove this case. I mean, the accusation is legally insufficient. It's outside the statute of limitations. She shouldn't have to stay in jail, you know, based on that.
And Your Honor, with all due respect, and I'm not trying to, you know, undermine PD Bartels in any way, shape, or form, but Your Honor has made her ruling. I'm not sure how many times we're going to revisit this during the calendar, but proper notice was not given. This defendant was arrested on a bench warrant. She did fail to appear in 2022, so it wasn't 5 years ago. It was 3 years ago where she failed to appear and was in the wind until she picked up new charges and was rearrested.
And I'm sorry, Mr. Bartels, based on that, I am not going to give her a signature bond today. That's for sure. And it looks like litigation manager Lewis has come back.
I did want to chime in just a little bit. I did get assignment for this case. It's going to be assigned to Judge Patsy Porter. She did make bond on those Superior Court charges, the felony charges she's in on, and the case that you're talking about, the COV Miss Falk, there was never a bench warrant issue on that case. It was just
Well, it showed a failure to appear.
Yes, it did, but a warrant was never issued. She got
Okay,
picked up on
so-
new charges that she just made bond on.
Got it. Okay, then my apologies.
Yeah,
So
this
she
state-
failed to appear, but a bench warrant was not issued.
Correct. So she only
But
got
she
picked up on the felony charges that she made bond on. The case that we're talking about now is the only thing that's holding her in.
And that was during the middle of the.
And the state did put on the record that she bonded out on the felony charges, but that the felony charges were recent, as in 11 days ago. As for the fact that she did not receive a bench warrant, I will say that doesn't change the fact that on March 2nd, 2022, she failed to appear. The court, for whatever reason, decided not to issue a bench warrant for her failure to appear, but did notate it in the clerk record that she failed to appear.
And the main reason for that not doing it was because it was in the middle of the pandemic. And I'm not aware that she ever got notice.
2022?
Yes.
March of 2022?
No, I was gonna say that was not in the middle of the pandemic. Is that correct, Deputy Fogg? I don't think.
Yes.
March, and we were talking about March of 2022, 2 years after the pandemic started.
Well, it's still, I know that I was in that courtroom at that particular time. I know it took at least 1.5 to 2 years before we were back to normal with jury trials.
Okay, that's a different statement, but that we were not in the middle of the 2022, we were.
So we
over
were
the pandemic,
tail end of
right?
the pandemic, we can argue, we were in the pandemic.
Well, okay, let's see what the options are. Ms. Cameron, I can try to get the case reset for a week for a hearing, or you could enter a plea on your own. Do you know what you want to do?
I wish I could say something because I didn't know I had an LTA. I was not signed a paper to no mail for no court date at all. Because it was a whole incident because Courtney stayed under me. I stayed on top of Courtney. I ain't never went through her door, went near her, none of that. Any court dates I have, I never missed a court date in my life. I went to all my court dates. If I had knew that I had a court date, I would have went to that court date.
Ms. Lewis, is there any indication that a notice was sent?
This was a Orca case. This is when we were first starting off with Orca. So this was like when they had open court, when they were just pulling cases with the Orca cases for, the COVID cases, because the case was accused during the pandemic time. And this was on a status conference counter. So that's part of why a warrant was not issued, because it was a status counter. They just marked it was FTA. I'm not seeing any notices returned because this was a citation only case at the time. And the state just accused the accusation back in 2022. So whatever information that they had on the citation, that was the address and stuff. I'm not seeing a recording of anything was returned because I don't physically have the file folder in front of me. I don't know if Miss Young can check the file folder to see if there's any return notices in there or anything, but it doesn't really have a lot in those file folders because they were citation only cases at the time. Because
I have the file folder.
and I don't know if you could check and see any notices was returned in there or.
No notices were returned.
Okay, so it was just a status conference that she missed. And I think I don't know what the procedures were during Orca, what they were doing with those kind of cases, but they did not issue out warrants. I know that because it was during the pandemic time.
Right.
Do we know if a notice was actually sent?
Yeah, I can check and see. Hold on. I can know. I'm sorry about the delay, Judge. I'm sorry.
It's okay.
$4 million people died from COVID in 2022. So I think that's still
Yeah, a notice was generated on February the 20th, February the 16th of 2022. It was going to an address of 79 Holly Road, Southwest Atlanta, Georgia.
What was that address again?
It was 79, two numbers, 79 Holly, Holly Road, Southwest Atlanta, Georgia. That was the last address that we had on record that information went to. And that was the address that was on the citation at the time. And understand there's two other cases in this case because it's a co-defendant. I think she's a co-defendant to these cases. There's two other.
Two.
Yeah, and those in bench warrant status and one is closed.
Well, again, I've requested a signature bond, Your Honor, based on the age of the case, the fact that it can't be prosecuted, and I think her lack of any legal history since then, except for this new arrest, which hasn't even been indicted yet. She still has the presumption of innocence. If the court's not inclined to grant a signature bond, I think, Ms. Cameron, you would need to decide whether you want to try to reset it for a week for a hearing on a motion to dismiss this case, or it's your decision whether to enter a plea or not. We can't hear you, ma'am.
I don't want to sit another week. It's crazy how y'all trying to get me to sit here for a week, and I did not know that I had a LTA or I had a court date. That's not my mistake. That's the court mistake. I'm not. I don't want to sit here. This is crazy. I'm sitting here for a case. They don't.
Well, I don't think it's a court mistake. They mailed the notice, correct?
That's
They
the
did,
wrong
Your Honor.
address.
And
That's the
was
wrong
that your address at that time?
No. The address where was my address at that time was the address where that incident happened. That's where I was staying in my daddy. Their address, I told them, I gave them a new address where I stayed with me in Courtney.
No, I'm talking about back in 2020. I'm talking about back then, not now.
No, I never stayed with my daddy in 2020.
But that's your dad's address on the Holly.
That's my dad. That's my dad's address. That's not my address.
It's probably linked to you back then.
Because of an incident between me and my dad. That's probably why. But I ain't never stayed at my dad's address.
Well, that's not really the question at the moment. It's an address associated with you on a prior case.
Yeah, it's associated. Yeah, it's on all my addresses still under my name, but I don't use the address at all. No
what is the state recommending?
Your Honor, the state's recommending that Your Honor remain with their prior ruling that this case would go to Judge Porter's courtroom. This is kind of, I hate to belabor the point, but this is kind of why Judge Morrow, when we have cases like this, sends it back to the courtroom it belongs to, because this entire back and forth needs to be done per notice in a courtroom before the trial judge.
Right. Yeah. Yeah.
I would argue this is just obvious on its face, but.
Well, but it doesn't matter. It still has to have proper procedure. And as honest as it may be on its face, it may or may not be once there is research done. And with the COVID cases and ORCA, there was a whole line of procedures with that. And I don't know, honestly, that she's denying that was her address associated with her. We didn't get a return mail. So the notice did go out, but nevertheless, I wholeheartedly agree with the state. Don't want to revisit this on this calendar to take up time. that it needs to go back to Judge Porter. There needs to be a properly noticed hearing. And it needs to go before the court to determine what to do. And how they want to address the COVID case.
Well, you know, again, I can't advise you to enter a plea on this. I think if she can have excellent grounds for appeal. And it's unjust that she's going to be sitting in jail waiting for a hearing on a case that can't be prosecuted. You know, that's my position. If she wants to enter a plea, that's up to her, but I can't be a part of that.
Yeah, but as her counsel, you have to file the proper motions as well so that it properly gets before the court.
I would know, Judge, a general demurrer can be made orally or at any time, even during a trial.
And we just got the case yesterday. I mean, basically.
I'll stick with my earlier ruling. We'll send it back to Judge Porter. And get it properly noticed and scheduled.
Very well. I'll be following up with that, Your Honor.
All right, thank you.
It's just, yeah, we need to. I mean, it's absurd.
I'm gonna take a plea. I'm just gonna have to take it to trial. Yeah, I'm not staying here for something I didn't do.
Well, and you shouldn't. You should not plead to that. I don't know that I would be comfortable taking a plea from you today, honestly. Because
whole another week. I didn't know I had a court date. I got 3 youngest kids that need a mother. Nobody else.
I understand. I do understand. But you have outstanding criminal cases that have to be addressed in the proper
way. That's the first time I ever got in trouble. That's the first time I ever got in trouble with the law. And my mom running me out for them 3 cases. The only thing that's holding me here is for that stalking charge. He explained it to me. The only thing that's stopping me from going home was the stalking charge. That I did not stalk her. It was no excuse for me to stalk her at all.
Okay.
So
I apologize. But you do have representation for it. But again,
I'll look at here.
If we do the plea, I don't know, Mr. Bartels, what
the other option I could suggest, Judge, and this would involve Ms. Falk agreeing to do this, but if we could reset the case to Tuesday SAP, if the state wants to spend that time researching it and perhaps reconsidering their position, that might be a way to possibly resolve the case. I'm duty attorney on Tuesday. I'll probably have to do SCA because it's the day after Memorial Day. But that would give the state 5 days to look into the case and possibly reconsider.
State has no objection to resetting it to the 29th.
Okay.
It should be
29th.
29. Okay.
Mr. Bartels, did you accept that, the 29th?
That would be agreeable, Your Honor.
All right, let's do that. Reset it to the 29th. Let the state research. And maybe you all can come up with the.
Okay, I will put together a motion, Your Honor. I mean, I know that Ms. Falk will research it, whether or not I do that, but I will start working on that today.
Okay, great. Thank you.
Can I take a plea? I want to take a plea deal today. I just need to go. I want to go home. I don't want to stay here another day, another day, another week. I want to go home. And I'll take a trial.
Your Honor, if we could, I think if PD Bartels and his client speak in a breakout, we can move on with our other cases because we need to our other cases.
Yes, let's do that. You all can speak in the breakout, PD Bartels, and you can explain to the client.
Yeah, maybe they could call. I think we're pretty much done.
Yeah.
They can call courtroom 2. That might be easier.
We'll give you a call, Bartel.
Okay, thank you. I'll be by.
All right, thank you.
And Your Honor, it's not a problem to set it on the 27th. If Ms. Falk is okay with that, I can reset it on the 27th.
State is requesting it be reset on the 29th, Ms. Young.
All right, it'll be reset to the 29th. Let's see if they come up with anything different, while they're talking.
Hey,
Do we have any more cases?
We do not, Your Honor.
Mike, I've got to talk to a client.
Oh,
We're actually, Ms. Kim. What are we doing with,
I'm sorry.
one second. Position 30.
Position 30, give me 1 second. Oh, I was told that yesterday he was moved to
Can you make?
transfer to Oconee Jail. However, right now he's medical reset for
On the felony.
jail officer.
Okay. Well, the judge is not gonna give you a signature on it. Do you think the judge will even?
And if courtroom 2 could mute, I just don't want
He
a
just
privileged
did.
conversation to be overheard. Okay,
you
thank
just
you.
muted. Yeah, thank you for your point.
Position 30 will be reset to 529.
Okay.
Ms. Falk, there is a felony transfer on position 31. Was the transfer granted? Or are we?
That's what I'm trying to figure out. This is one of the cases I'm covering, so let me see if the documentation was ever sent over.
Yes, ma'am. I'll hold for that one. So on the main calendar, Your Honor, yeah, that's the only one we're holding on the jail transfer.
Okay,
I'm sorry. 1 second, wrong announcement. Let me make sure before I say that's it. Position 25, Patterson. The conflict.
That's actually a conflict attorney case.
okay.
Okay, it'll be reset to Tuesday. Who attorney? Okay, 527 for conflict attorney.
Okay.
And Miss Smith on position 31, I have not received a response from the DA's office, so if we can reset that to 529.
529.
Yes. I should have an answer by then. The main person who is handling those requests is out until the 27th.
Okay.
529 for status update on the transfer.
And what is the case where we're resetting because of the conflict attorney?
It is position 25,
25.
Shaka
Okay.
Patterson.
And that's getting reset to the 29th or the 27th?
I thought you said the 27th, but whichever.
I'll do the 29th. Let's just do the 29th.
Well, I will say, given the jail
They
time
have
on the
extra time anyway, so.
right, given the jail time on the case, it will not hinder them.
All right. If you all are ready, I'm ready to go over the calendar
Okay.
for the SAP and the add-on.
Okay.
Okay.
Position 1 was a plea. Position 2 reset to 529. 3 was released. 4 plea. 5 non-proc. 6 reset 527. 7 reset 612. 8 reset 529. 9 reset 529. 10 jail jury waiver. 11 negotiated plea. 12, 13 released. 14, 527 add on. 15, 527 add-on. 16 waiver jail jury. 17 release. 18 plea. 19 pled guilty on 515. 20 jail jury waiver, same announcement for 21. 22 reset 529. 23 plea. 24 non-pars. 25 529. 26 plea. 27 reset 529. 28 reset 28 and 29 reset to 6-3. 30 reset to 529. 31 reset to 529, felony transfer status. 32 reset to 6-3. 33 6-3. 34 6-5. Add-on, position 1 with a plea. Position 2 is reset to 6-3. Position 3. Ms. Kim, what reset date did you ask for Mr. Smith?
That was a negotiated plea.
Mr. Smith was a plea. Thank you. And position 4 was reset 527.
What was the status on position 1 and 2?
I believe there was a reset. but I'll-
One was a plea.
1 was a plea and 2 is reset to 6-3.
Okay,
Reset to June 3.
Yes,
position number 1 was a plea? I don't, on the add-on, I'm sorry, the add-on.
the add-on, yes.
Yeah,
No, it was not a plea.
so
Carter.
position number 1 on the add-on calendar was reset to what date?
June 3, 2000.
Okay,
Okay,
thank you. And position number 2 on the add-on calendar.
6-3.
Thank you.
All right. Yeah, so the only plea on the add-on, the only case on the add-on calendar that took a plea was position 3.
Oh, 3.
Excuse me, Judge, whenever you're ready, we're gonna go back to position number 2 when you're ready.
2?
Yes,
No, I really don't. I've made my ruling, I think, twice. I'm not sure why we keep going back to it.
Well, Your Honor, can we unmute Fulton ACDC? I'm still unclear on what Ms. Cameron wants to do. She said she wants to enter a plea, but if the court consider bond reduction, I understand the court's ruling on the signature bond. Her parents can put up some money. We would ask the court to consider a $1 cash bond on this. I know from experience, the Fulton County Jail charges a service fee. It's about $80. So her parents, who may be able to post a bond, could put up some money. I think that amount would be sufficient to ensure her appearance at court. The court granted that if she bails out, then we wouldn't have to worry about a hearing and the trial court could address it when she's out of jail.
Hey, what say you?
Your Honor, I think I am a little bit, and I apologize if some of this frustration is leaking out, but I feel like Your Honor has ruled the first time, the second time, and now we're back here for a third time on the same case with the same facts. Nothing has changed. And so it is setting up a situation by which if the court rules that's just still open over and over and over again to relitigate it until the court just caves and gives the defense what they're asking for. And so my frustration is I have already argued this same argument 2 other times, and now we're back here for a 3rd time, re-arguing it again after the court has made their ruling twice.
Right. This is not going to change. I understand you're advocating for your client, Mr. Bartels. I get it. And your client, I understand. Yeah, and I understand she wants to go home. I get that too. But factually, we have this situation and it has to be properly put before the court, and it has to follow processes and procedures. And just to take a plea, just to any old thing to go home, I'm not comfortable with that either. I'm really not.
So the court's not comfortable taking a plea, and the court's not comfortable waiving her signature bond.
No, I don't think she qualifies for a signature bond.
Well, I think that's within the court's discretion.
It is. She's, had an address that's associated with her father, she said, but it is associated with her. That was the address at the time. I guess she's updated it now. And if I'm correct, Deputy Falk, and then while she was on bond, she caught the felony, correct?
She was out on, let's see, it wasn't on bond because it was a citation, but while
Right.
she was out on the citations, yes, she did pick up this new felony case. It's currently pending in the DA's office under that 21 PI number that
Right.
happened 11 days ago.
Okay.
I will start working on something today, Your Honor, and get it filed.
Okay. Thank you. Who do we have there?
Hi, my name is Jazziana. I was actually like subpoenaed to come in today for the Devontae Irwin case, and am I gonna have to come a different day?
Let's see.
Because I see nothing really happened with that, so I'm just kind of confused.
Yes, it's reset to May 29th.
Okay.
So that's, go ahead, Deputy Falk.
Oh, sorry, Miss Jessiana. I know you spoke to Miss Cheney. She can give you a call and just kind of talk with you about what happened.
Okay.
Okay.
Thank you.
Thank you.
Thank you.
Bye-bye.
Bye-bye. And that's it. Anything else, Ms. Young?
Unless Ms. Kim have an announcement, then we'll do the comp calendar.
Right. And we do have 2 pleas on I believe we may have 2 pleas on the competency calendar, so we will need to keep the court reporter to address those.
Okay.
Could you tell me what positions?
Excuse me. Let me pull up the most updated competency calendar and I can give you those positions.
Okay, and I just want to check, Ms. Kim. I do want to verify position 4, Nathaniel Taylor is going to be reset to 527, correct?
Correct.
Okay, I just want to make sure.
Thank you.
And I can't answer for Peter Bartels as to whether they were accepted or not. I did submit 2 recommendations, and that is, let me just pull this up. It was just taking a moment. Leon Phillips, which is position 4 on the competency calendar, and Angela Morrow, which was position 3 on the competency calendar.
Thank you, Ms. Paul.
This calendar, which one?
I'm sorry, what was the question, Your Honor?
On positions 3 and 4, I believe.
Right. Yeah, Ms. Morrow and Mr. Phillips will both be entering pleas. That's correct. The state's made an offer. There was a little detail we have to work out with Ms. Morrow. I guess we can talk about it now. Ms. Falk, can you hear me?
I
Well,
can.
Yeah,
Your
I
Honor,
understand the state's position.
Attorney Bartel, hold for 1 second. Your Honor, do you want to clear, everyone? Are they excused before we start the competency calendar?
Yes,
For everyone that does not need to stay.
I didn't know if we had anybody else on. I can't tell.
It looks like the only people remaining in the Zoom are court staff, the probation,
That's correct.
pretrial, and the advocate. So I
I
think we're
bounced. Judge, you need me?
No, how are you?
Good.
I should hold you hostage and keep you,
Keep
but I
him,
won't
Your Honor.
today.
Please keep him.
Don't do me like
Please
that.
keep him.
Y'all need, to stop the recording on this, if y'all all wanna go in a breakout room and to deal with this, or how y'all wanna handle the competency calendar? I can't hear you, Ms. Falk, you on mute.
Oh.
apologies. If we can just turn off YouTube, we can still remain recording, but we can just turn off the YouTube so it stops broadcasting.
There's nobody else in the courtroom here.
Okay. No
Yeah.
problem, I just wanna make sure how y'all wanna handle it, it's no problem.